You're listening to Bloomberg Law with June Grasso from Bloomberg Radio.
In a significant escalation of his battle with the Fed, President Trump is moving to fire Lisa Cook, the first black woman to serve on the Federal Board of Governors. In a letter posted on Truth Social late Monday, Trump said he had, quote, sufficient cause to fire Cook, citing allegations that she submitted fraudulent information on mortgage applications, although she's not been charged with a crime. He reiterated his position in the Oval Office today.
Seems to have had an infraction, and she can't have an infraction, especially that infraction, because she's in charge of, if you think about it, mortgages, and we need people that are 100% above board, and it doesn't seem like she was.
Cook says she won't step down. Her lawyer, Abby Lowell, says they'll sue and that Trump's attempt to fire her, based solely on a referral letter, lacks any factual or legal basis. Joining me is constitutional law expert Harold Krent, a professor at the Chicago-Kent College of Law. Can we assume that the president is giving in on one point, that he needs cause to fire Cook, because he said in a letter posted on Truth Social that he had sufficient cause to fire her?
And that's the surprise, is that the president has deviated from his earlier line, which said that he can fire anybody he wants to for any reason whatsoever. And by inserting in the letter that he had cause to fire Cook, that's suggesting the type of admission that he does need to have cause to fire her as a governor of the Federal Reserve. He could always abandon that later in court, but at least at this point, this is an unusual claim for him that he does need to have cause.
This all goes back to FHFA Director Bill Pulte alleged that she lied on loan applications for two properties, claiming she would use each property as her primary residence. And Trump wrote in a letter sent to Cook yesterday, at minimum, the conduct at issue exhibits the sort of gross negligence in financial transactions that calls into question your experience and trustworthiness as a financial regulator. Is that cause?
So this discharge of Cook raises three issues, in my mind anyway. And the first is the one you've articulated. What is cause? And there is a dearth of precedent at the federal level as to what is cause to justify dismissal of someone who's otherwise protected in the government's employ. For instance, is there a reason to fire someone for something they do outside their job, something they did in terms of they got into a fight at a bar? Is that cause? What happened here is at least akin to that. It's like something that happened in her private life, not with respect to her job. That's one issue. But there are others. Can a judge second guess a president's determination that the individual is not fit for the office? That's a question of what kind of deference the courts will give to the determination of cause. And then there's the initial question of whether the president had to give any kind of notice and ability to respond before the discharge. If instead of being federal governor Cook, this was a question of an employee, the law is clear that the employer needs to give notice and opportunity to be heard prior to the discharge, except in an emergency situation, and this isn't one. So the procedural issue may well be raised in this case. And then there's a third issue that I think could be relevant too, which is we don't have a lot of precedent about if a court says that there is not cause to dismiss the individual, will the court in equity force the president to rehire someone, or will they just say that you were unlawfully terminated and the government has to pay back pay? Obviously, in the famous Humphreys Executor case, which is still limping along, the court didn't have to decide on the reinstatement issue because the FTC commissioner Humphrey had already died and the estate was carrying on the case. So we don't know whether there's notice ahead of time. We don't know what cause means, and we don't know, even if there is no cause, whether the court would require reinstatement or would that be a trenching too directly upon presidential powers.
So the fact that he threatened to remove her and asked her to step down because of this, is that notice?
Who knows? Did he say, I'm worried about the loan applications? What's your side of the story? I mean, that's what's supposed to happen for most federal employees. It's not a full hearing. It's just a notice and opportunity to respond. And did he ever ask, what about this finding by Pulte? What do you have to say about it? And will that be constitutionally required? We don't know. It is for employees. Maybe it's not for officers, but the courts will have to tell us.
Also, this happened before she became a Fed governor, and her attorney is saying there's no factual or legal basis. This is all based on a referral letter from the head of the FHFA, Bill Pulte, who has sent similar referral letters for Democratic Senator Adam Schiff of California and New York Attorney General Letitia James, who are on Trump's enemies list. So there are no findings, and it appears not even an investigation.
Yeah, the question then is whether this is all pretext and whether the court will second guess whether there is cause and effect. The issue is just because someone is accused of doing something that may be unethical doesn't mean that they did something that was unethical. And of course, who is to judge that anyway? So sort of the substance of the case about whether there's enough cause to remove the Federal Reserve governor is, up in the air. And my guess is that if the courts do take that issue up, the courts would say that you can have cause to dismiss somebody for conduct unrelated to the conduct of their job, but you'd have to make some kind of determination whether or not, given what the government is convinced that she did, whether that would impair her ability to do her job effectively. So, this case raises a lot of issues that have been circling around discharge of federal officers, and we simply don't know the answers.
Looking at the ruling earlier this year where the Supreme Court said it would shield the central bank from the type of at-will removals of board members that they've allowed Trump to do, at least temporarily, at other independent federal agencies. Do you think that just stands for the fact that it has to be for cause, or does it stand for the Fed is different?
You could say that President Trump is doing the trial balloon, and if it goes well and he can get away with dismissing Federal Reserve Governor Cook, then maybe he can remove Powell because of the overruns in terms of redecorating and restructuring his building, right? That may be cause as well. So he may be trying this as a kind of trial balloon to see what he can get away with. On the other hand, it's unclear what principled way that the Supreme Court could say that the president can't fire the head of the Fed, but they can fire all other officers of the United States. That helps the markets, but it doesn't seem to be very logical either. So we just don't know.
And has the Supreme Court ever defined what for cause means?
No, it has never defined it. It has said, dereliction of duties is one word that they use. But I think that it's a small step from dereliction of duties to say, if someone, I had a case, for instance, that had to do with an administrative law judge who was disciplined for having a fight with a family member. And the courts upheld that and said that's cause. So it's a small step from dereliction of duties to say, if someone didn't behave well outside of office and that casts a cloud upon the integrity and the ability of the office to do its congressionally assigned tasks. So again, if the court ever reaches that, I would think that they would side with the president on that you don't want to limit cause just to what's happened in terms of carrying out the duties of your office. You'd want to expand it to say any kind of conduct then that would undermine your ability in the future to conduct your affairs in an appropriate way.
Coming up next on the Bloomberg Law Show, I'll continue this conversation with Professor Harold Krent of the Chicago-Kent College of Law. More on Trump's plans to expand the use of the military in American cities, and a Trump-appointed federal judge tosses the administration's lawsuit against all the federal judges in Maryland. I'm June Grasso, and you're listening to Bloomberg.
Mr. President, do not come to Chicago.
President Trump is threatening to expand his use of the National Guard to crack down on crime in U.S. cities. And after deploying the Guard to L.A. and D.C., Chicago seems to be next on his list.
When I have some slob like Pritzker criticizing us before we even go there, I made the statement that next should be Chicago because, as you all know, Chicago's a killing field right now. And they don't acknowledge it. And they say, we don't need him. Freedom, freedom. He's a dictator. He's a dictator. A lot of people are saying maybe we like a dictator. I don't like a dictator. I'm not a dictator.
City and state officials condemn Trump's plans to deploy the National Guard. Mayor Brandon Johnson says the crime rate in Chicago has been falling for years. And Governor J.B. Pritzker says they'll take Trump to court if he tries to send the Guard to Chicago.
If we are not even in the top 25 most dangerous cities, then why are we now being targeted by the Trump administration for a military occupation? We are being targeted because of what and who we represent.
First thing we're going to do is take him to court because it's illegal, it's unconstitutional. Frankly, it's un-American to send troops into an American city the way that he wants to fight crime. There is literally a law in the books that says he's not allowed to do that.
I've been talking to Professor Harold Krent of the Chicago-Kent College of Law. President Trump is threatening to expand his use of the National Guard to crack down on crime in U.S. cities. And after D.C. and L.A., Chicago seems to be the next on his list. Crime statistics for Chicago this year show a 30% reduction in homicides, 35% reduction in robberies, nearly 40% drop in shootings. Chicago is not on the 25 most dangerous cities in the U.S. I mean, what authority does he have to send National Guard in?
Whatever authority he has, it's certainly even less than he had in L.A. and less than he had in D.C. In L.A., there was a fiction that there was a type of invasion, if you will, of undocumented into the city, into Los Angeles, which prevented the regular law enforcement authorities in California from responding adequately. In addition, the fiction could be spun out that it was difficult to enforce federal law there because of the presence of so many individuals without documentation. And that's what necessitated sending in the National Guard. Those theories can't apply to Chicago. There is no invasion here, and there is no problem of enforcing federal law here. With D.C., of course, the president serves, in essence, as a governor of the National Guard in D.C., and so he can call out and approve the use of the National Guard for whatever reason, even though there was a decline in the crime statistics in D.C. as well. So Chicago is another step forward, and I think it's a very dangerous step forward. Clearly, the framers didn't trust the idea of a standing army. They were worried about using the army for regular law enforcement. And there is no authority to use the National Guard for those sort of ordinary law enforcement mechanisms as well, and not even trained for it. So we have a specter. In other words, if the president can call out the National Guard for Chicago, he can call out the National Guard for any reason he wants. And we all should be very deeply concerned about that, because that is edging us, one step closer to autocratic rule, because it means that the president can use the National Guard for his own bidding for whatever reason he wants to, and there are no constraints on his use of armed forces.
Hal, do you think that Trump might try to use Title 10 of the U.S. Code on Armed Services about the federal deployment of National Guard if there's a rebellion or danger of a rebellion against the authority of the government of the United States? Or could he try to invoke the Insurrection Act?
I mean, there's no insurrection, and I don't think he's not even articulated a possible insurrection. He did try to do something like that for Los Angeles, but he hasn't tried to do that for Chicago, and I think it would be incredibly far-fetched. And I agree that if there were federal facilities that were in danger, then he could utilize those powers to protect federal facilities, but that's not the case. Or if ordinary law enforcement had totally fallen apart, he could call in for the Guard in that context as well. We do have a couple of precedents, right? We have the precedents of calling out the National Guard to help with desegregation efforts in the 1950s. We have the precedent of calling out the National Guard when there was really no general typical law enforcement because of the riots that tore the streets up in the 1960s, particularly after MLK was assassinated. So we have some precedents, but they're not ordinary law enforcement as in Chicago. And so this is simply a dramatic expansion of the ability of a president to call the National Guard if he in fact does so. And I think it's something we should be deeply concerned about.
So Chicago is a sanctuary city, right? So could
Correct.
he Could he say, well, Chicago is blocking in some way, they're not helping with the federal immigration enforcement because they're not assisting us in finding out where people are?
Yeah, I mean, it could be that the claim here is that Chicago authorities are frustrating federal law enforcement ability to apprehend and deport those without documentation. That's not his claim here. He hasn't stated that. And obviously there's probably no proof of it anyway, but he hasn't even made that as a thin veneer to justify his use of troops. So that would be closer to the LA model for use of troops as opposed to what he said so far about Chicago.
And we're waiting still on Judge Breyer's decision about posse comitatus in the LA case. But the appellate court there did allow Trump to keep the troops in LA.
They did, and of course it wasn't a full decision. It was just based upon a stay of what the lower court had ordered. So even after Judge Breyer reaches his decision, there will be an appeal to the Ninth Circuit. But I think it's important. I mean, I think the Governor Pritzker in Illinois is ready to file suit as well, and this is the only way, except for a military challenge, that the governor can contest the legitimacy of what the president is trying to accomplish.
Also, Chicago's mayor called on Trump to release something like $800 million in anti-violence grants that were canceled in April by the Justice Department.
No, I think the point is that, if the president wants Chicago or Los Angeles to enhance their crime-fighting ability, then why did it cancel the grants? And it should allow for these communities to hire more police, to get better weapons or even surveillance mechanisms in order to fight crime. And so putting this on the National Guard, who are not trained for that, is probably counterintuitive and may result in worse kind of law enforcement than otherwise would take place. And the other thing to note is that the president is selected Los Angeles, D.C., and Chicago, which are all clearly Democratic strongholds, and he's making no mention of cities like St. Louis, New Orleans, and Memphis, which have crime in excess of those in D.C. and Chicago, but happen to be headed by Republican governors. So that, again, will give a strong flavor of what the president is trying to do, is just sort of show his might in the face of states and cities which would otherwise object to his governance style or, in fact, the substance of his governing itself.
And a judge has ruled last week that the Trump administration can't deny funding to Chicago, L.A., Denver, and other cities because of policies that limit cooperation with federal immigration efforts because they're sanctuary cities or counties.
Yeah, and this is a reprise of litigation back in the first Trump administration when he tried to remove funding from the so-called sanctuary cities. And simply, you can't do that unless Congress gives the green light. And Congress has not allowed police grants, for instance, in this case, to be predicated on the police agreeing to be helpful to ICE agents in rounding up those without documentation. Congress could make that. It would be an interesting policy call. Congress could make it, but it hasn't. And that's what the courts have held. And to go back to the National Guard issue, I'm hoping this is just a headline grabber, kind of in-your-face move by the president. But if he really sends troops here, then he can send troops for any reason at all, including what frightens me most is around the midterms. We don't want to give the president an idea that he can frighten people or deter them from voting by sending National Guards to the polling places in various jurisdictions during the midterms. And so that's what frightens me the most. And I think it's important then to fight against the use of the National Guard for sort of personal political reasons, as he's doing in Chicago.
And yesterday, Trump also signed an executive order establishing specialized units in the National Guard to address crime in cities. Though it's unclear how the order will work in practice. What's your take on that?
Well, I think that viewed charitably, the executive order is consistent with the Constitution. It's saying we want to have special training if there is a moment such as with George Floyd or other kinds of rioting, if local law enforcement cannot exercise their authority to keep peace within the cities. That it's like a ready force, just in case it's needed. By itself, I think the president could probably do that. The only question is when he can deploy this specially trained force. Can he do it, again, during the midterms? Let's hope not. But just the training by itself seems to me to be within his ability to coordinate as commander-in-chief.
There was a lot of legal news today. Let's turn now to another development. A federal judge threw out the Trump administration's lawsuit against Maryland's entire federal bench. That means every federal district judge in Maryland. This was a suit over an order by the chief judge of the Maryland District Court that stopped the immediate deportation of migrants challenging their removals for 2 days. And the Justice Department had said the automatic pause impeded the president's authority to enforce immigration laws, and it sought a court order blocking it. And federal judge Thomas Cullen, a Trump appointee, in an emphatic ruling that underscored the extraordinary nature of the suit, called the suit potentially calamitous. And he also criticized the administration's attacks on the judiciary, highlighting in a footnote that White House officials in recent months had described judges as rogue, unhinged, and crooked, among other epithets.
And what was, I think, interesting about the opinion is that part of it is predicated on the immunity of federal judges as well as the clerk of the court. That may be a little extreme, in terms of the future. But what he also added was that in this context, you would never have an injunction, that the courts would never enjoin courts from enforcing an order. That's simply unheard of in the courts of equity and is inconsistent with norms of separation of powers. And so that, in essence, the Department of Justice and the Homeland Security didn't have standing to bring the case. And that became much an easier sell because, and indeed, as we discussed earlier, the government could have easily challenged a standing order in a different way by raising it on appeal in a case that it might lose in terms of the immigration matter before the court. So I don't know if all the reasoning will be upheld by the Fourth Circuit, but I think the underlying decision to dismiss this poorly crafted lawsuit will be upheld by the Fourth Circuit.
It was hard to see why the Justice Department brought this suit because it is unprecedented, and I use that word a lot lately. And the Trump administration has already filed a notice of appeal, so more to come. Thanks so much, Hal. That's Professor Harold Krent of the Chicago-Kent College of Law. Coming up next on the Bloomberg Law Show, who's in charge of the New Jersey U.S. Attorney's Office? I'm June Grasso, and you're listening to Bloomberg. The Trump administration has tried various maneuvers to keep Alina Habba, Trump's former personal attorney, at the top of the U.S. Attorney's Office in New Jersey. But a federal judge has ruled that Habba's appointment was not lawful and disqualified her from participating in any ongoing cases.
I am the pick of the president. I am the pick of Pam Bondi, our attorney general, and I will serve this country.
The continuing maneuvering and confusion over Habba's role has led to federal criminal cases in New Jersey basically coming to a standstill because no one knows who's in charge. And the judge's decision could mean that any actions taken under Habba since July 1st are open to challenges by defendants. It could also reverberate across the country because the Justice Department has been using similar complex maneuvers to extend the tenures of other Trump loyalists as interim U.S. attorneys in California, Arizona, New Mexico, and New York. Joining me is Ann Joseph O'Connell, a professor at Stanford Law School. Federal Judge Matthew Brand said that Alina Habba is not lawfully holding the office of the United States Attorney and has been in the position without legal authority since July 1st. It gets quite complicated, Anne, so please take us through it.
It is a lengthy decision with several rulings. Let's march through the opinion to see how the judge made various rulings. So the first thing the judge did was to decide whether Ms. Habba was lawfully serving under the specific interim U.S. attorney provision, 28 U.S.C. 546. And when he looked at that provision, he determined that the 120-day time limit started when the first appointment was made under the statute. So that first appointment was not actually Ms. Habba. It was Mr. Giordano. And his appointment started, and the 120 days ran from that and ended, according to the judge, on July 1st. So although Ms. Habba had more days, if you were counting to 120 from when she started, the judge held that was not the right way to consider the clock. So that was the first decision, that starting on July 1st, Ms. Habba was not lawfully serving under Section 546. Now, there was a ruling kind of connected about whether the government could turn to the Vacancies Act, because the criminal defendants at issue argued, well, if Ms. Habba was not lawfully serving under 546, the government could not turn to the Federal Vacancies Reform Act, which provides a way of getting in temporary acting officials, not just for U.S. attorneys, but a whole range of positions. And the criminal defendants argued that actually the Vacancies Act did not apply to U.S. attorneys because of 546. And this was the one place the judge actually ruled for the government. The judge said that 546 was not the only mechanism for temporary service for U.S. attorney spots. He said that the Federal Vacancies Reform Act was available. Now, that then turns to the next ruling. He said that Ms. Habba was not lawfully serving under the Federal Vacancies Reform Act. So the act applied, but she was not lawfully serving. And the primary reason for that ruling was that as he interpreted Section 3345 of the Federal Vacancies Reform Act, you cannot have a first assistant to the vacant Senate-confirmed role be named after the vacancy in the position. And for the judge, the vacancy is not the end of interim service under 546. It's the end of when the last Senate-confirmed U.S. attorney left. And so Ms. Habba was put into a first assistant slot after the prior confirmed U.S. attorney left, and the judge held that was not permitted under the Federal Vacancies Reform Act.
What about her delegating to others?
There was one more ruling about if she was not serving under the Federal Vacancies Reform Act, could she perform the job through what is known as delegation? And that was the final ruling by the judge in the 77-page opinion. And he held that under another provision of the Vacancies Act, 3347, that Ms. Habba could not perform the role of the U.S. attorney without the acting title and through delegation. He said that also was not permitted.
Judge Braun was concerned about allowing stacked interim appointments that would allow the administration to effectively avoid the confirmation process and do away with the Senate's advice and consent.
Yes, so this was about his ruling on 28 U.S.C. 546. This is where you get what are known as interim U.S. attorneys. There's this 120-day time limit, and then after that, the district court may choose someone to serve in the role until a Senate-confirmed person comes into the position. And the government argued that it could make successive 119-day appointments so that it never hit the 120th day where the district court would then have a role. And the judge rejected that. The judge said, well, if you can do that, you could have 119 days on one appointment and 119 days on another appointment and keep going. And indeed, the judge said you could have a longer term for an interim U.S. attorney than you could for a Senate-confirmed U.S. attorney, because there's a statutory provision that says that Senate-confirmed U.S. attorneys have a 4-year term. Of course, they're at-will leaders, so the president can fire them before that, but they can't serve longer than 4 years. And he said, under the government's interpretation of 546, you could actually get in someone for longer than 4 years.
Do you think that determination is correct?
I do. The judge relied primarily on the text of 546 in making its ruling, looking at appointment. There's discussion of definite and indefinite articles. I think the text is a bit more ambiguous. I would read the text to say that it is possible that you could have a successive 120-day or 119-day appointments. But the purpose, when Congress put these time limits back in 2007 was clear, right? They wanted restrictions on the Attorney General's powers to name interim U.S. attorneys. So for me, a text plus a purpose argument would say, yes, you can't just have successive 119-day appointments. But the judge did talk a little bit about purpose and legislative history, and I guess I would weight the purpose and legislative history more than the judge did and acknowledge that the text is more ambiguous than the ruling does.
But you would come out at the same point as the judge did? Yeah, that you could have one 120-day appointment, and then the district court could name someone, or you could turn to the Federal Vacancies Reform Act. In New Jersey, criminal cases are at a standstill. Arraignments have been delayed, hearings, plea agreements, grand jury proceedings, even a trial. Who is in charge now? The Deputy Attorney General, Todd Blanche, the number 2 at the Justice Department, has been putting his name on some of the New Jersey office's work in the last couple of days. I mean, does that solve the problem? Who's in charge? Well, it solves the problem temporarily. I mean, if Mr. Blanche is affixing his signature, that would be okay, because under the various statutory provisions, the Deputy Attorney General has the same power as the Attorney General, who has power to do anything that a U.S. attorney might do. So that would be okay. I think they need to sort all of this out. I mean, the judge did stay his own ruling. There was no request from the government to stay it. He stayed it himself until it gets sorted out on appeal, right? This is going to get sorted out on appeal one way or the other. And the government, I think, has a decent chance of winning on appeal. But obviously, if the government does not win on appeal, they don't want to create more problems for themselves in the intervening period. And didn't the judge say that Habba can't even supervise? And I take it that what she has been doing is supervising because she has no experience as a prosecutor. Well, it's a little unclear, right? She's not supposed to be carrying out the role of the U.S. attorney. So he does allow for a special attorney to the Attorney General to do some tasks, that would be helpful in the U.S. Attorney's office. And indeed, we can get to this whole point about delegation, actions, whether they could be void but could be ratified later. So there is some room for her to act, but it's going to create a lot of headaches until or unless the appeals court reverses. The Trump administration has done similar maneuvering with other U.S. attorneys' offices in Los Angeles, Nevada, New Mexico, and upstate New York, where they've tried to sidestep or override the Senate confirmation and the judicial appointment process. Does this ruling implicate those U.S. attorneys as well? Yes, so anyone who is serving as an acting U.S. attorney because they were named to the first assistant role under this judge's ruling, if they were named to the first assistant role after the departure of the last Senate-confirmed U.S. attorney, who almost certainly was a Biden administration pick, in many cases, right, they left before January 20th at noon, those people, under this reasoning, would not be properly serving under the Vacancies Act. We can anticipate that defendants in those jurisdictions are going to file suits as well, challenging the authority of the U.S. attorneys. Yes, and it's not just limited to U.S. attorneys. The ruling about the Federal Vacancies Act, which this judge made, says that any first assistant who is serving as the default acting official under the Federal Vacancies Reform Act has to have been in place before the departure of the last Senate-confirmed person in a covered position. Well, that covers U.S. attorneys, but it covers hundreds of more positions. So all of those first assistants, now leading that organization, whatever federal agency, in an acting capacity, those people, too, are serving in violation. So that would have really broad implications. Yeah, so the first thing we were talking about, these successive 119-day appointments, that's only about U.S. attorneys, right? That's, about 90-something positions. The second ruling about the timing of the first assistant, that applies to hundreds of positions. And I should note that for both of these rulings, actually, the one specific to U.S. attorneys on 546 and the timing of the first assistant,
this is the first judicial ruling on these issues anywhere, right? So we don't have a ruling about successive U.S. attorney in the interim capacity under 546. There's sort of language in a footnote in a much older case which suggests that it's actually permitted, but we've never had a ruling from any court saying that successive interim U.S. attorney positions are prohibited under 546, and the much broader ruling that the first assistant has to be in place prior to the departure of the last Senate confirmed person. This judge is also the first to make that conclusion.
And the Trump administration has already said they're appealing the decision. So the Third Circuit, I guess, will be the first circuit to rule on this as well.
That's right. And then there's another ruling that has implications far beyond U.S. attorneys. So once the judge decided that Ms. Habba was not lawfully serving under the Federal Vacancies Reform Act, he had to turn to the fallback argument of the government, which was that it's okay if she doesn't have the formal acting title under the Federal Vacancies Reform Act. Ms. Bondi has named her under Section 515 and other provisions regarding the Department of Justice as a special attorney to the Attorney General. And in that role, according to Ms. Bondi and the government, Ms. Habba could carry out all the functions, all the non-exclusive functions of the U.S. attorney position through delegation. And the judge ruled that this is not permissible. And this does go against other court rulings. So the Ninth Circuit and the Court of Appeals for the Federal Circuit have found that under a slightly different provision, but that also talks about functions and duties, 3348 of the Vacancies Act, that the government can delegate non-exclusive duties down to someone, and there's no problem there. And this is widely done in the government, in large part because of a broken appointment system. There are many Senate-confirmed roles of assistant secretary and the like, kind of lower levels, that are delegated down, and this ruling would prevent that.
Any final thoughts?
This ruling by Chief Judge Brand did not actually make any constitutional decisions. Because everything could be resolved on statutory grounds, there was no need to make constitutional rulings. So that's one thing. I think the Constitution was in the background as he was interpreting statutes, and he says that, but there are no constitutional rulings in this decision. The second thing that struck me was about when the vacancy occurred. Right, because we have all these clocks, right? We have this discussion about a clock on the interim service under 546, and then we have a clock under the Federal Vacancies Reform Act. And the Office of Legal Counsel, in an opinion in 2003, held that these clocks run separately. But what's interesting to me is that the judge, in a footnote, actually footnote 153, just to give a flavor of how complicated the decision is, says that he dates the vacancy for the purposes of the Federal Vacancies Reform Act as not when the interim service ended. Instead, it's when the last Senate confirmed person left. And this matters to the Vacancies Act clocks. So that means that we're counting, right, either the 300 days at the start of an administration, we're counting back to January 20th. So even if the administration found someone who did qualify under the reasoning in this opinion, for example, they were Senate confirmed to another job, right? That's Section 3345A2, right? You could make Todd Blanche the acting U.S. attorney for the District of New Jersey under the Federal Vacancies Reform Act, and this judge would not have a problem with that. But the time clock for Mr. Blanche to use the title acting U.S. attorney for the District of New Jersey dates back from when the last Senate confirmed person left, and it kind of gets rolled over with the new administration. So from January 20th. So it's actually not that much time, even if you actually got someone who met the requirements under the Federal Vacancies Reform Act. And then the last thing I'll say is there is this complex reasoning at the end about what is void and what can be ratified. And Chief Judge Brand is trying to distinguish this case from the Federal Circuit case and the Ninth Circuit case by saying those cases were about kind of what could be ratified under Section 3348, and he's focusing instead on Section 3347, which talks about how the Vacancies Act is exclusive with regard to functions and duties of covered positions. And so he says, well, Ms. Habba can't do all of this stuff under 3347, but I'm going to acknowledge that it seems like anything she could try to do is non-exclusive, so it could be ratified under 3348 by, the Attorney General, for example, someone higher up. And so this gets into a little bit of weirdness where the judge at the end is saying, well, she can't do it, but if she does it, someone else could ratify it. And so I think this issue about 3347 and 3348, I think that's really going to be the heart of the government's appeal, along with this idea of the timing of the first assistant.
Thanks so much, Ann, for taking us through this complex area. That's Professor Ann Joseph O'Connell of Stanford Law School.
And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.